Welcome to For the Record with Greenwood Law.
Welcome to For the Record with Greenwood Law and attorney Dylan W. Greenwood, founder of Greenwood Law in Winston-Salem, North Carolina. Dylan is a criminal defense attorney representing clients in both state and federal court, known for his high-level personalized representation and hands-on approach to every case. I'm Lisa Mosby, your host, and today we're talking about what actually happens after a federal arrest, a process that moves fast, involves multiple agencies, and surprises most people who have only experienced the state system. Welcome, Dylan. Thanks for being with me.
Oh, happy to be here. Thanks for being here too.
Yeah, Dylan, many people imagine a federal arrest works the same way as a state arrest. Why would we think otherwise? But what are the first major differences someone would experience the moment federal agents take over?
Sure. And there are quite a bit of similarities. The handcuffs are similar, and, the process of going in front of a judge is similar. You go in front of a magistrate. Same with North Carolina, at least initially, but a lot of things have to be done by a North Carolina district court judge for a first appearance now, with some of our changes in bond rules. But for what somebody can expect is the way the federal government operates for its investigations. People fall into usually two camps. Camp number one would be if a big, long investigation and a group of people usually gets arrested all at one time. And those people get arrested, whether it be due to a traffic stop, or there's a warrant, or they're served in their home, or whatever else. And they're brought in for an initial appearance. Group number two is when people have been notified, for instance, or they figure out that they are under investigation by the federal government. And they get somebody like me involved in that investigation before an initial appearance or an arrest ever occurs in federal court. And we're working with federal authorities to either see if they will back off of the case, or to maybe steer the case a certain way, either to remain in federal court or to go to state court, because we think that might be a better venue for the charges that might come about, or to maybe explain part of it to where it's not as serious. And typically in those cases, not all the time, we can work out a scenario where we're turning someone in, and we actually schedule a time for them to meet with a federal law enforcement agency, typically at a federal building, for a turn-in date for a scheduled time to go in front of a magistrate. So it's a little more straightforward. Regardless of those two camps, the way it significantly differs from state court is the involvement initially from United States Probation, in the sense that they have to interview everybody that comes in for an initial appearance to figure out what's going on with their finances, to figure out whether or not they need a court-appointed attorney, whether or not they have a potential third-party custodian, whether there are potential recommended release conditions that will be sent to the magistrate judge for their consideration. And the whole process happens extremely quick, like to the point where oftentimes you're having an initial appearance, but maybe you're actually continuing it for maybe a week to be able to more adequately prepare to address issues of detention and that sort of thing. And that kind of thing happens pretty regularly, because more often than not, if you're under a very tight timeline, you're better off working with United States Probation to figure out if there's some sort of factors that you can put together, or a third-party custodian that someone might have that's fully vetted by the time you go to court, that's recommended to a judge, where they can say, hey, we're okay with this person get out as long as they stay with this individual. And the reason why that is just so important is because in this particular jurisdiction, the Middle District of North Carolina, that seems to be the key more often than not for somebody to be released ultimately. It doesn't have to be that way, but a lot of times it can be. The other way in which that might happen, again, is if we are involved in the investigative part of it pretty early on, is if we have somebody that is actually flipping and starting to work potentially for the government, in which those cases, everything can be scheduled very streamlined, everything is done pretty closed off, and because that's a sensitive issue where somebody's safety is potentially very much at stake. And being sensitive to that, I think usually everybody in the system is pretty sensitive to that aspect of those cases.
And Dylan, many federal cases start long before the arrest itself. What tends to happen behind the scenes in the weeks or months leading up to that moment?
You might as well even include in years. I mean, oftentimes these investigations go on for a year or more. They don't have to, but a lot of times they can. And the behind the scenes, if we're involved, it's working directly with U.S. attorneys, because U.S. attorneys are more involved with the investigative aspect of a federal case than any state prosecutor ever is. So it's working with U.S. attorneys. It's working with federal law enforcement. Sometimes it is sitting down preemptively with law enforcement to proffer information about something, to go ahead and being cooperative with an investigation. If we feel like, or we get the sense that it is going a certain way, sitting down and having those conversations can certainly affect the charges that come about, the ultimate outcomes in the case. For instance, I had one where we did that. We sat down early on and we were able to very much steer the case in a certain way so that my client got particular considerations in sentencing, because we were able to explain certain things so early on that it did not take him out of consideration for those special considerations at sentencing. We were able to kind of steer that a certain way, nail that down, and then because of his cooperation, all of a sudden that affected his initial appearance in detention to the point where he was getting out. We didn't really have to worry about the state moving for detention in that case, even though he was in a case where it was presumed that he should have been detained. So there are a lot of things that can be done behind the scenes, not just being cooperative, but also pointing out deficiencies in a case, preemptively getting third-party custodians lined up so that you're ready more early on in the process, and maybe you don't have to continue the case or what have you. And to some degree to see whether or not there's certain ways in which the case might be heard at certain times versus another, just as a convenience thing for everybody. That's a small thing, but everything matters at the end of the day.
And you made several references to people that are involved in these cases, but once someone is taken into custody, who are the main players involved, and how does early interaction between the agents, prosecutors, and the defense counsel shape the direction of the case?
Yeah, that's an excellent question. The main players involved are obviously the accused, the defense attorney. I think the federal government does an exceptional job of making sure that you have an attorney at all stages of the game. I think that the feds do that a much better job than state court, but that's also just the nature of the process. It's not anything that's a detraction from state court. It's just the nature of the process, because there's just less cases that come through federal court. But the other major players are the U.S. attorney, because ultimately they're going to stand up there and make recommendations to the judge about what they think is appropriate in a case, or whether or not they're willing to come off their presumptions for detention in certain cases. And what they say matters quite a bit. The United States probation officer that's doing the initial interviews of this individual that's accused of a crime, that person has a great deal of power, because their recommendations get heard and listened to very closely by United States magistrate judges. And then the final player is the United States magistrate judge, because ultimately they're typically the ones that make a decision as to whether or not there are conditions of release that would reasonably assure that you're going to appear to court and not be a danger to the community, and then you can actually get out, because that's what they're looking at.
And you mentioned how quickly federal courts move. What typically occurs in the initial appearance, and how does that hearing itself set the tone for what comes next?
So, I mean, at initial appearance, detention hearing, I mean, you're getting informed of the charges. You're trying to figure out whether or not someone needs court-appointed counsel. Do they understand, everything that's going on? And then are there certain conditions of release that can reasonably assure that they're going to come to court, or not? And sometimes an initial appearance in a detention hearing can be used as a way to get some information about a case early on. So by having that detention, those hearings, if you actually go forward in the hearing, the government has to put on evidence. Typically, they have to put on evidence to justify why you're there, what's going on, what the need is for, keeping somebody locked away. And it can end up being a tool for the defense to find out some things about the case while somebody is testifying under oath. Or like in a federal supervised release case, you could have an initial appearance and detention hearing. And I had one where I got a federal probation officer up on the stand, and I started asking him questions about stuff. And I quickly realized that he was just kind of speaking off the cuff. And the things he was saying just didn't seem to be backed up by anything. And I ultimately asked him, I was like, where is all this stuff? He's like, well, it's on my computer. I was like, well, you have your computer here? And he said, yeah, but it's going to take me a while to access it. And I said, Judge, I've got time. I think this is pertinent. Let's let him access it and see whether this stuff is valid or not. Got on his computer. Sure enough, it didn't exactly line up with what he was testifying to just off the cuff. And, I'm not sitting here and by no means making it sound like that person was intentionally trying to deceive or anything. I don't think he was. I just think he thought he knew about his case and the notes he made, 6 months prior. Maybe he just didn't remember as clearly as he thought he did. I pointed that out to the judge. I was like, listen, he could have done X, Y, and Z in this. He could have served my client with these violations, weeks before he got out of prison where he was. I said, he elected not to. I was like, my client tried to reach out to him to let him know. I said, it's documented right here. I was like, that's not somebody trying to subvert the government. He's not trying to subvert supervision. Ultimately, I mean, the magistrate was like, I hear everything you're saying. He was like, but in a supervised release case, there's a presumption to detain people, and I got to go that way. He was like, but if this were any other case, he's like, yeah, he would be getting out right now. I was like, okay, thanks for that consolation.
And detention and bond issues are handled differently in federal systems. What factors does the federal magistrate judge look at when deciding whether someone stays in custody or is released?
Sure. I have seen more often than not, instead of like for instance, in state court all the time, magistrates, district court judges, superior court judges, they'll set, $20,000 unsecured bond, $50,000 secured bond, just kind of depending upon the charges, what somebody's record is, if they've ever failed to appear to court, that sort of thing. I'm not saying that does not happen in federal court. It definitely does. There are judges that will set a bond to make sure, secure that somebody is going to come, and they've got to post that bond in some form or fashion. But more often than not, in this district, it comes down to whether or not you have a third-party custodian, or you've worked out ahead of time with U.S. attorney, or you can figure out in the days preceding a bond detention hearing if there are factors that the U.S. attorney is comfortable with, where basically everybody is coming forward to a judge and saying, hey, this is what everybody's kind of figured out and good with. We think these factors add up to, addressing the concerns of the court, making sure that this person's going to come to court and follow through on the prosecution while we figure this out. And be a part of the process. Being part of the process is not just showing up to court. Being part of the process is being able to aid and assist in your own defense. And that's one of the biggest arguments that we have on our side, which is saying, hey, this person being out can help us better. And it's important for them to be out because they have access to things that we don't necessarily have access to, or it's easier for them to get access to, or just them being out to be able to provide for their family. Anything like that can help them aid in their own defense because maybe they need to afford an expert, or maybe they need to do, any number of things in their case where being out can certainly help. But a court will ultimately look to the factors of safety to the public and whether or not we think this individual is going to show up to court and not run off somewhere. So that's what they're really looking at.
And how do early plea discussions or informal conversations with the prosecutors begin? And I'm going to do a follow-up on that one. And what does early communication usually focus on in those cases?
It begins usually with phone calls or just in-person meetings. And that's because a U.S. attorney is assigned to a particular case, so you know who to talk to. You're not, and that's the difference, because a lot of times in a state case, somebody gets charged, they go through some of the initial procedures, the initial appearance, bond, whatever else, and then somebody from the DA's office gets assigned to it. Or they get assigned to it kind of contemporaneously, so they're not really involved. They're trying to get up to speed on the case at the same time you are. Not so in federal court. U.S. attorney usually knows completely what's going on in the case. And then you're getting involved in it and you're going, okay, what do you think you have? Explain this to me. It's my understanding that, XYZ is going on in the case and you think it's going to lead to, these particular sets of charges, but what's going on here? And a lot of times you can have a nice back and forth. I mean, I'm not saying that, in no way, shape, or form is a U.S. attorney just going to hand over everything or display all their cards, because usually there's investigations ongoing or there's more to it than you can see. But sometimes you can read between the lines on what seems to be important. Does it seem to be important for your client to potentially cooperate? Does it seem important that their case hinged on a particular search? Or maybe they applied for wiretapping type stuff where their entire case hinges on that. And that's a really tough thing to apply for. And the warrants for that have to be done very specifically and correctly. So, I mean, there's all types of aspects of that are going on. So you're trying to ascertain what's going on, trying to explain a little bit about maybe some things related to your client, maybe stuff that doesn't even involve with the case, but maybe just characteristics of who they are. Do they have a family? Do they have a good job? Do they have ties to the community? Do they have family support? And talking about those things to sort of lay a bit of a groundwork sort of preemptively for what's being considered when it comes to potential detention issues and what an initial appearance might look like. So every bit of that is kind of at play in that when you can get in early enough.
And I think the last question I have for you is federal sentencing guidelines. The federal sentencing guidelines add another layer of complexity at this early stage. What aspects of a case begin influencing how those guidelines might apply later?
I think somebody's ability to be polite and cooperative with law enforcement can affect that. There is a certain aspect of the sentencing guidelines that talks about basically acceptance of responsibility, that you've accepted it so much that it's basically like to your detriment. You are so cooperative that you're almost overly cooperative to your detriment. That's a kind of a unique one in the sentencing guidelines. I don't see that applied too often. I've argued for it before, not with any success, at least the times I've done it. But it was worth the argument in the cases that I had. You can also look at it from the standpoint of, like the case I mentioned earlier, where there are certain facts that were involved in this overall case, where there were concerns on our end that if they were looked at in the wrong way, not only could it take certain pieces of relief away from your client, but could actually add enhancements in the sentencing guidelines. That is a very significant concern. And so we went at that in that case very early on, and not only quelled those concerns and got the focus away from that, and rightly so. I mean, I think some people could have interpreted what happened in that case in that severe way, and I know people who would have done that. But I think the U.S. attorney in that case actually got it right, in that it wasn't that way. And not only did that take away potential enhancements from the sentencing guidelines, but it actually opened the door for different types of relief for that individual, where all of a sudden they maybe weren't facing all the mandatory minimums. That was able to come off. We were actually able to argue for that person to have a significantly reduced time in prison. He was facing mandatory minimums of over 10 years, and we were able to ultimately get him a sentence around the 4-year range, 3 to 4 year range. And because of what we were able to work out, and so much of that was at those initial stages of that investigation and the days leading up to his initial appearance and detention hearing in federal court.
Dylan, I think that's where we'll leave it today. Thank you so much for sharing your insights and your experience in these cases.
Absolutely.
Folks, that's it for today's episode of For the Record with Greenwood Law. If you'd like to learn more about attorney Dylan Greenwood and his work at Greenwood Law, visit dwg-law.com. You'll find helpful resources about criminal defense in North Carolina, from state charges to federal cases. Thanks for listening. And don't forget to leave a review, and subscribe to the show so you don't miss the next episode.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.